Is there a legal separation in Florida? I got a question from a viewer recently that asked that question, and I'm going to answer it today. So, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and let's dive in. So, let's say you don't want to get a divorce, but you want to have alimony and or child support. And can you do that? Can you enter into a legal separation in Florida? I hear a lot of people say, no, there's no legal separation in Florida. Well, there is. So under Florida statutes, 61.09 and 61.10, they're very similar, but they both talk about support and maintenance unconnected with a dissolution of marriage. So if you are living in the state of Florida and you want support under 61.10, you can get that support, but your spouse can also get time sharing. So it's kind of a two-edged sword under 61.10 because you may be reluctant to give time sharing, but they'll have that right. Under 61.09, it doesn't talk about time sharing. The statute simply talks about getting alimony and child support. So there's some strategy around that. What you might want to do is to file under 61.09 rather than 61.01 if you're the spouse wanting to receive child support and or alimony. But if you're the spouse that wants to separate and maybe move out and make sure you have time sharing secured with your children, then you're going to look at statute 61.10. Both of you have to still live in the state of Florida, and there's got to be jurisdiction for the state. But yes, you can have a time sharing plan entered into there. Okay, so what are some of the reasons why someone might want to file an action for support and maintenance unconnected with a divorce? Well, first, some people, because of religious reasons or their faith, don't believe in divorce, or they don't want to be the one filing for divorce. So they'll file for this kind of legal separation because they need alimony and support, child support. Same thing for the person moving out that might want a time sharing plan, but they may not want to be the one filing for divorce. So their belief system may be that they don't believe in filing. There's also people who are still not sure they really want a divorce. And so they're willing, they definitely feel like they need to separate. Maybe to work on the marriage, maybe hoping that time will improve things. But again, they need support during that process or during that time period. So this is available. This is available to family law clients who don't want to file for divorce, but who need child support, alimony, and time sharing. Now, there's some brutal realities here. You may not want the divorce, so you may file this, and your spouse may file a counter petition for divorce. I've seen it lots of different ways. I've seen we file a petition for child support or alimony unconnected with divorce, and the other side simply wants time sharing, and they're willing to work within the framework of a kind of legal separation. But sometimes they do file the action for a dissolution of marriage. But then my client's kind of okay with that because they weren't the one actually filing for divorce. It was their spouse filing for divorce. Okay, you can use this also to benefit moving forward if the case or the marriage doesn't resolve and reconcile. So I have many times drafted parenting plans or these legal separation agreements that tack on we're gonna try to work on the marriage and reconcile the marriage. Maybe I'm representing the wife, the husband's had an affair, she needs to heal off and she wants to make sure he's not gonna do that again. And so they work toward reconciliation. But it says in the agreement, if he cheats on her again, that then this is the way the permanent parenting plan will look. This is the way equitable distribution will look. This is the way the alimony will become permanent. The child support will become established, not just temporary. So there's a way to include, like, equitable distribution is not part of the statute 61.09 or 61.10, but you can, by agreement, draft it into a legal separation agreement in the event that the marriage doesn't reconcile, or in the event that the divorce goes forward for whatever reason. So it can be very strategic. I do remember a case I had where there was infidelity, like I mentioned, on the part of the husband. He was very much wanting to reconcile and saying he would never do it again. So he was very motivated to enter into an agreement that said, sure, he won't do it again. And if he does, she gets this, she gets the house, she gets this amount of alimony, this amount of child support, she gets her car. So we wrap the whole thing into a full marital settlement agreement, parenting plan, into this legal separation agreement, or at least referenced it so it would be pretty much automatically entered if there was further infidelity, which unfortunately in that case there was. But it saved the parties having to renegotiate everything after the fact, or after the legal separation. It was already taken care of. I've also had cases where it worked out, the legal separation, they reconciled, we dismissed the proceedings, and no divorce ever happened. I've had cases where they were legally separated for 3-4 years, they reconciled, they had additional children, and then still came back in with issues. So you never know in family law, unfortunately. I think people who are watching this video who may be in a situation like this may realize, wow, I don't know what's going to happen in my case, but I need to go see an attorney, get some advice, see what my options are, and so forth. So you do have an option for a legal separation in Florida. I hope this has been helpful. If you know someone who might benefit from this, please share this video with them. If you liked the video, please subscribe to the channel, like the video, and become a viewer of the Healthy Family Law Attorney. So leave a comment, and I'll see you next time. Thanks. Bye.